Yeah, please, Your Lordship. I beg to mention item number 3 on behalf of the GHDC. Lordship, I'm for the petitioner.
What is this matter about?
Regarding the appointment. Your Lordship, may this matter may be taken up after 1 week, Your Lordship. Lordship, no objection.
On premier by the respondent GHDC, list this matter after 2 weeks.
Your Master, Lordship.
May I please, Your Lordship? I beg to mention item number 5, Your Lordship. The conducting counsel is not keeping well, Your Lordship. Your Lordship, kindly the matter be taken up after 3. We are for the petitioner, Your Lordship.
Who's for respondent?
Sir Devnath, Your Lordship.
He's not here. Have you sought his consent?
No, Your Lordship.
So let the matter be called up. In the meantime, you try to
Yes, Your Lordship.
contact him.
May I please, Your Lordship? My Lord, I beg to mention daily causes number 6, my Lord, hearing number 6, the daily, my Lord. On behalf of the state respondents, my Lord. Mr. Senior GA, my Lord, Mr. Sen is the leading counsel here. He is indisposed today, my Lord. If this matter can be taken up on other occasion, my Lord. I will inform the other
Who's
side.
for the petitioner?
Senior counsel N. Mosika is appearing. He is on legs on the other side. My Lord, my colleague is here.
Yes.
I'm for respondent number 6.
Private respondents, my Lord.
Private respondent.
I'm appearing on behalf of the petitioner, my lord. No objection.
How long? Yes, miss. Tell me how long?
My Lord, subject to Lordship's convenience, my Lord, he is not available only today, my Lord. For that reason, I'm paying for a joint.
On pre-made by the respondent, state respondent, on the ground that the senior GA who is conducting the Leonard Senior GA who is conducting the case is indisposed for the day, and the same not being objected to by the petitioner. That is adjourned. List the same after 2 weeks.
My Lord, may I also mention another matter, my Lord? Supplementary number 2, my Lord. This matter was heard yesterday, MECL matter. Here, Lordship has directed if I may speak to the department concerned. My Lord, yesterday, certain arguments were placed regarding the procedure, my Lord. I have taken instruction with regard to the other aspect, whether we are ready to come to an amicable settlement, but I have been informed by department that my procedure has been actually conducted. So, my Lord may give me week's time, my Lord, we can bring on record, my Lord.
You should have done that in your...
My Lord, the only reason why this was not brought into record, because, my Lord, we were ahead of the appellate authority. I was second leg, my Lord. However, my friend has made an argument before the appellate authority. So, my Lord, that portion, as Lordship has heard, my Lord, my argument was based after the appellate authority has taken cognizance of the matter. But my friend has brought onto record the procedure which was before the appellate authority. So, my Lord, those procedures. So, my Lord, I have been informed by the department that they have actually done certain. So, my Lord, I may be allowed to examine the documents.
You mean to say that 10.3 was complied with?
My Lord, yes, notice were issued, but the parties were also informed. That is what they have informed me through phone, my Lord. So, I have to examine the record, my Lord. So, since a short date, I couldn't examine the entire document. I just required 1 week time. If the documents are proper for adjudication of this matter, then I may be allowed to bring into record by an affidavit, my Lord.
Miss Arpulni London. You're standing counsel or...
My Lord, I'm just a counsel. I'm a counsel, my Lord.
You're a counsel for the respondent. Is it MECL or...
My Lord, yes.
MECL has submitted that on instruction being sought for in this matter, the concerned official has verbally informed the counsel that the same could not be forwarded today, and accordingly accommodation is sought for as far as the hearing of the matter for today is concerned. So we'll give it up to a week then.
A week, my lord. Only a week. Highly obliged.
Reply made by the on the same not be objected to by the petitioner. This is matter up to 1 week.
May it please, Lordship. Lordship, I beg to mention item number 4, Lordship, from the main list.
If all the matters are mentioned, then what is left for
Lordship,
this court?
I humbly pray for some accommodation, Lordship. My senior is currently, he has to part heard matters before court too, Lordship. So, some accommodation may be granted. Subject for the petitioner, Lordship.
That prayer is made on behalf of the petitioner on the ground that the senior counsel who is conducting the matter is indisposed. Accordingly, matter is adjourned. Let's see him after 2 weeks.
Highly obliged.
Actually, nothing is left.
Supplementary cause list, item number 1.
Yes, please, my lord, I filed this application, an application for impleadment, my lord, in the instant matter.
Have you given copy to
My lord, yes.
Lordship, as per my learned senior's submissions on the other date, we don't have any objection to the petition or the applicant's audience being impleaded, Lordship.
So you're one of the parties who have sought to be impleaded.
My lord, yes.
I believe there
I'm
are.
the parties to the before the title suit, my lord, before the trial court.
You were a party there also.
Yes, my lord.
And I believe somebody else has a. Who was it?
Lordship, I believe on the other date, Mr. Philemon Nombre had was appearing for.
Mr. Philemon's Nombre file an impleadment in the other CRPM.
In the CRPM.
Not in this CRP 11.
Not yet.
CRP 11.
So he is not.
You're not interested, my lord, in this.
They only file an impleadment in CRP 36, which your lordship has.
Yes, Mr. Nombre is here.
But I have not filed any judgment on this because my interest is in the other
Okay, so okay.
matter.
So you are the only one who is
My lord.
really interested.
2 applicants, my lord.
Where is your application?
Miss case number 12, my lord, of 2023.
excuse me. But Mr. CCT, our learned counsel, was submitted that the opposite party number 3 herein had instituted a suit before the trial court, before the civil court, being TS number 11 H of 2020 for declaration and permanent injunction. The suit was aimed primarily at the petitioner herein. In course of the proceedings, an order dated 8/10/2020 was passed in Miss Case number 9 H of 2020, arising of the said title suit aforementioned before the trial court. With the order pass being with the order pass directing the parties to in the suit to maintain status quo. It is also submitted that during the pendency of the suit, who was the OP1?
My lord, is the state of Meghalaya represented by the Secretary ERTS Department.
The OP1 oblique the petitioner hearing had filed an application under Order 7 Rule 11 of the Court of Civil Procedure for rejection of the plain. The trial court on hearing the parties had, by order dated 1/4/2021, dismissed the said application. Being aggrieved by the said order dated 1/4/2021, the opposite party oblique petitioner herein had preferred this instant civil revision petition before this court. This instant may ask for the court, for this court. In the course of these proceedings, the applicants herein have now come before this court seeking to be pleaded as party respondents on the ground that they were also parties in the said suit. The prayer made was with reference to the fact that when this revision petition was referred before this court, they have not been arrayed as necessary parties, not been arrayed as party respondents. It is therefore prayed that this petition may be allowed and necessary orders be passed. Mr. H. Karwala, additional senior GA, appearing for the petitioner, oblique opposite party number 1 and 2.
1 and 2.
Has submitted that there is no objection to the prayer made in this petition, and this court may allow the applicants herein to be pleaded accordingly. What about this opposite party number 3 here? You are representing. Similarly, Mr. Emil Dopier, appearing for the respondent, opposite party number 3 herein, has also submitted that there is no objection to the prayer made by the applicants. On consideration of the submission made, the prayer of the applicant is hereby allowed. They are accordingly pleaded as party respondents in this case. Petition disposed of. Atau main case there, I will heard Mr. CCT sama Land Council bagi. Land Council was submitted that this court by order dated. Kan terus
18 Malord.
It is 18. Order date 16.
This court has allowed the Meghalaya Archery Team Welfare Association (MATTWA) as well as the Khasi Hills Bookies Welfare Association KHBWA capital itu to be pleaded as party respondents in these proceedings. It is therefore prayed that the cause title may be amended suitably. On consideration of the submission made, the registry is directed to amend this cause title. The matter will be heard weeks hence.
After 2 weeks, Malord.
2 weeks.
2 weeks. Since the other matter has been listed after 2 weeks, let it be after 2 weeks, Malord.
2 weeks.
Lordship.
Anything?
No, Lordship, since my senior was already pressing for early, so that the Lordship's memory would still be intact, because we have already argued majorly in the other CRP, Lordship. So if can happen next week will be easier.
In fact, I'm yet to receive the petition, even the petition, Malord. The direction will be given to the petitioner to
So
supply a
we
copy of the
supply by today. But if we can have it by next week, Lordship, to your Lord's convenience.
I go paragraph 2. Mr. H. Karolang, the additional synergy, has submitted that relevant copies of the petition will be supplied to the newly pleaded respondents in the course of the day. Okay, there's nothing much here.
My lord.
2 weeks,
2 weeks.
Right, Lordship.
From daily cause list, item number 1.
Lordship, this service matter with regard to promotion Assam Rifles. In brief,
You have not been promoted.
Your Lordship, this is the second round of litigation, just broad aspects of the matter. Firstly, when the first writ petition was filed before this court, we had sought to challenge that the adverse entry in the ACR has not been communicated to him. So we had filed a writ petition, and this Honourable Court was pleased to pass an order with a direction to the respondents to furnish us the adverse entry in the ACR, and thereafter, if we are aggrieved by that ACR furnished by them, then we can file a representation before the Assam Rifles. That was the directions of this Honourable Court. Now thereafter, after the directions of this Honourable Court, we file a representation to furnish the ACR, and thereafter the ACR was furnished. After the ACR was furnished, not a complete ACR was furnished, there's a one page. Thereafter what happened? We filed a representation representing before them to upgrade us and not to look into those adverse entries, because at the initial stage those ACRs was never communicated to us, though it was communicated to us later after directions of this Honourable Court. And this Honourable Court directed them within 1 month to pass a speaking order. Thereafter, after filing of the representation, they pass an order, which they say it's a speaking order. Now what happened in the impugn order? Briefly, it was a general discussion about his entire career. Thereafter, they came to our representation, where we have demanded for promotion because those adverse entries were not communicated, and there was no finding also as to why are those adverse entries entered before by the whatever the rating. Now what happened in the speaking order which they have passed, there was no finding why the adverse entry was there. That was never furnished in the order. And number two, very strangely, they say that if we allow him, if we grant him promotion, they say that if we grant him a promotion, it'll be a floodgate. That means other people will come also for redressal of the same kind of grievances. So my argument at this stage is that they cannot come with such kind of finding. If I am legally entitled to promotion, they ought to have granted me, not by saying that if they grant me, others will come. It has to be treated as a precedent not in the sense, but singly that it should apply only for my case only. That is basically the broad facts of the case. And now my latest instructions which I have just received also, he's come before this court for a prayer to grant him promotion with effect from 16/7/2018. Now in the meanwhile, I'm not mistaken, it was last year he's been granted the promotion, but not with retrospective effect, with prospective effect. On that I need to take instructions.
Or in the meantime, he has been granted.
He has been granted the promotion, but not from the date where he was superseded.
In the light of the fact that he has been granted promotion, so the remark made in the said order has no meaning now.
No, it's not that, Lordship. A challenge is still there that he should be granted from the date that he is entitled to.
That is true. That is, you see, now again, see, that's another aspect of the matter. Initially, your grievance was that he was not granted promotion because of the remarks made in the order or comments, whatever. But in the meantime, through passage of time, he has been granted promotion, albeit not as per your prayer.
My prayer.
You have, sought for promotion retrospectively.
Absolutely.
2018. So now that is the issue that remains.
Yes. But when was he promoted? That is still, I need to still verify on that.
Oh, when was he promoted?
When he was he
You don't
promoted?
have a copy of that?
No, I just received some information. Perhaps they'll be in a better place because he also is posted somewhere very far. I don't really know because this matter has been pending quite some time. So basically, these are two grounds.
Have you got any instructions?
I didn't get any.
You check on it and we'll see.
If I'll try my best to contact him and then ask him for a date so that we can pursue ahead.
Yes.
What is that? Only for that period.
Yes.
Because they can't come to a finding saying that no, others will come to court because.
No, see, now in principle, he has been, you see, he has been granted promotion.
Yes.
So nothing remains.
Nothing.
The only thing now is whether he has been granted promotion with effect from 2018 or prospectively from 2019.
Yes.
So that difference of 1 year is there.
Where where he was being superseded by his junior.
So how long?
10 days. By 10 days, I should be able to get the. I can keep it as a part heard also. We'll finish it on that day.
Mr. P. Nomburi, Learned Counsel for the petitioner, has submitted that in view of the latest development, wherein the petitioner is said to have been promoted, however, the exact details of which is not known to the Learned Counsel, it is therefore prayed that some time may be afforded to the petitioner to the Learned Counsel to seek proper instruction in this regard. Mr. Devna, the Learned CGC is also requested to inquire into the matter and to seek necessary instruction so as to clarify the position of the parties. On pre-meet, this is matter to 2 weeks.
Obliged.
Item number 5.
What is this matter about?
This is the matter about elusive. The person was going to retirement after this. He was getting the pension. So there was some litigation, and after this, in calculation, there was some mistake.
Calculation of pension?
Yes.
Because there was some litigation, and after this, some benefit was given to him. So in the meantime, when it was under process, at that point of the writ petition is filed. So after the writ petition is filed,
but why you have in the meantime, once the petition was filed, you could have recalculate or
recalculate and payment is made.
Then
payment is made.
So
after this, in my affidavit, I brought this aspect to the matters. So now it has been rectified and due payment has been made. So after this,
so he is not satisfied with that, or is he satisfied?
So now after this, they have filed the rejoinder. So there is nothing as such written. They are standing on the writ petition. So now only the matters. But according to me, there will not be any matters to be just again to hesitate. But still they are arguing this matter, then they can argue the matter. As per our calculation, it was admitted position that action was taken before filing the writ petition. So after this filing the writ petition, then when the calculations come up and it is make payment to his true accounts. That's why we didn't bring aspect of the matter before this route. Just we given in our affidavit, just due payment will be made.
Where are the details in your affidavit? Okay, so you have made, okay, only, that is only the first affidavit that you have filed.
This is only one affidavit.
And they have filed a rejoinder to that.
They filed
where is the averment made that
this
subsequently
is annexure
the annexure 10.
Annexure 10.
Page
Page 36 in my. There's due to litigation not only the petitioner, there were some others also about another 8 numbers, total 9 person. The total amount has come this 86 lakhs 83,000 and petitioner got 1,96,693.
Petitioner is number 1.
This number 1. Not only this petitioner, others also they are due to court order, and he got out this amount out of the court order, and his pension also.
Oh, he did not dispute this the amount paid in his rejoinder. He has not.
It's not disputed. And then his pension also in the next page 37 NHLV.
Yes.
Initial pension was there 10,515, and after this, after the 7th pay commission, this also need considered, and it has come 27,600. Now he is getting pension 27,600.
He is getting this pension from 12th December 2073.
Yes.
To 2073.
Date of retirement is 31st December 2006.
But why you written 12th December 2073? How old will he be then?
His service may be it was saving 12 December 1973.
Yes.
So this his date of enrollment maybe 1973. That's why he retired subsequently.
What 2073? We are.
Oh, this typing mistake.
This means how many years from now? 50 years from now. So you've only calculated that you'll get pension for another 50 years.
This may be I didn't say this typing mistake.
You file a document before court, you should be. Because this might be again question later. I was wondering there must be some system where you calculate pension to a certain till a certain period or date. But here it says from 12th December 2073 to 12th December 2073. How can it be? I don't know.
This may be just typing mistake.
Typing mistake, see, there are, if it is typing mistake, it could be in one place. But here you find it at 1, 2, 3, 4 places. And this has been forwarded to pay and accounts officer.
This is by the pay and accounts officer.
By the concerned officer, accounts officer of the ministry. How can he make such glaring mistakes? Anyway, we'll look into what the petitioner has to say.
Because in page 8 you will see, I think this on the page 8, paragraph 3E.
Page
8. Page 8, paragraph 3 with E.
3E. Yes.
It is also submitted that petitioner was rightly granted pension at the rupees 10,515 only per month with effect from 1/1/2007, and his pension has been correctly revised 27,600 rupees only with effect from 1/1/2016 as per Commission White Pension Authority number such and such. And this has been done on 18/8/2022. So how is it received? Almost 2073, and 2073 it is far away, and it is now 50 years
That's what I said. And then
I also didn't this.
When was this petition filed? 2022 only.
Yes, Your Lordship, 2022 last year.
So this order was 18/8/2022.
Yes. After filing the petition.
Oh, after filing.
After filing. They filed in the month of June 2022.
Yes, Miss, you do one thing. You check on this.
Yes, Your Lordship.
Get instruction.
Yes, Your Lordship.
If he has, if he's satisfied, or he has received, or if there's any grievance apart from whatever has been given to him,
yes,
then you come back with those instructions.
Yes.
Because if your initial prayer is that you have not received pension,
Yes,
that has been answered here. But whether you receive it correctly, rightly, or wrongly, that's up to you.
Yes, Your Lordship.
And process also here somewhere it is process also taken before that. Regarding the area pension, this process was taken in July 2021, saying that there is some mistakes and it should be corrected. And because this after the High Court orders, earlier there was some litigation, and then out of this High Court order, petitioner was supposed to have some benefit. And considering this aspect of the matter of the court order, the petitioner also entitled, and it was written how he will be entitled for it. And this was the period was there, 1st February 2012 to 31st April 2013. There was some benefit was given by court order.
So that has also been given to him.
So this one's given due to this payment has been made.
Okay.
And even accordingly, his pension also is given. And 7th pay commission also this given to him. This is the this whole several. And the due to statement also given here. This is the statement. Due to statement is there. Annexure 4, page 23.
Well, they must have. You see, but the fact is, they have received your affidavit, and they have filed the rejoinder. But you said nothing is there in the rejoinder.
But if still you receive this, if they can go through this due to statement, and if you are having anything, then I can look up to the matters. Because the due to statement is given Annexure 4.
If there are some mistakes here and there,
then definitely
that can be corrected.
When petitioner can see, petitioner is the main person who draw the pension and salary.
Mistake committed is one thing. Entitlement not given is a different thing.
Entitled as per entitlement, as per this, what's the entitlement? Before the petitioner is coming before the court, at that time they have started this one, and based on the judgment of this honorable court earlier passed in other cases. So on the basis of he is also entitled. So as per entitlement, the due diligence statement is prepared and it is being given. So still, if you are having any grievance, and then if in due diligence statement any mistakes you can point out.
On pre-made by the parties, seeking time to seek respective instructions as regard the latest development in this matter. Matter is adjourned for today. This is the same after 1 week.
After 3 weeks, Your Lordship, the conducting council is suffering from eye flu, Your Lordship.
Oh. This is after 3 weeks.
Highly obliged, Your Lordship.